Here are 5 Supreme Court cases that demonstrate why even liberals should have serious doubts about Ruth Bader Ginsburg. 1. Baxter v. Bracey. Ginsburg joined most of the court in refusing to hear a case that would allow the court to re-examine the doctrine of qualified immunity for police officers. This doctrine prevents police officers from getting sued except in narrow circumstances. Limiting the scope of qualified immunity could help tremendously with the fight against police misconduct, but Ginsburg refused to even hear the case on this issue. She refused to re-examine a very dubious, court-contrived doctrine that has almost no basis in law. 2. Kelo v. City of New London. In this case, the court, Ginsburg included, ruled that private homes could be taken from individuals and given to corporations without the homeowner's consent because this constituted public use under the eminent domain clause of the Fifth Amendment. Not only does this ruling have no basis in text or original historic understanding, pragmatically, it created devastating consequences for real people. As Justice Thomas noted in his dissent, this deferential shift in phraseology enables the court to hold, against all common sense, that a costly urban renewal project whose stated purpose is a vague promise of new jobs and increased tax revenue, but which is also suspiciously agreeable to the Pfizer Corporation, is for a public use. Something has gone seriously awry with the court's interpretation of the Constitution. Though citizens are safe from the government in their homes, the homes themselves are not. Everyone, especially the left, should dislike this disastrous empowerment of corporations over individuals and the public at large. 3. Gonzalez v. Reich. This case allowed the federal government to prevent the cultivation of marijuana that occurs solely in a state that has legalized its use. This case added more fuel to the fire of the failing drug war. Conservatives should dislike this case because it gives the federal government illegitimate Commerce Clause powers and diminishes states' rights. Liberals should dislike this case because it allows the government to regulate individual liberty and bodily autonomy. 4. Bennis v. Michigan. In this case, the court ruled that a car could be seized by the government without compensation because it was involved in criminal activity, even though the owner of the car was unaware that someone was using it for illegal purposes. This case further empowers the confused legal theory of civil asset forfeiture. Moreover, this case involved prostitution. Prostitution is not something that the government has legitimacy in prohibiting. It involves consenting adults exercising autonomy over their bodies. It only has victims because its illegality drives it underground into the black market. This is what creates the environment where women are easily abused. As noted in the Bennis case, Ginsburg supports these incredibly anti-women and anti-liberty prostitution laws. Justice Ginsburg argued that Michigan should not be rebuked for its efforts to deter prostitution. Every Supreme Court justice has cases that people will dislike. For all justices, though, these cases seem to occur all too frequently, and RBG is no exception.